Moving on with the next technical session. With Parivartan in any law comes new challenges. To discuss about the emerging trends and challenges in taxation laws, we have with us two intellectual persons. To chair the session, we have Justice Anita Sumant. Having done her BA, BL, and ML in Madras, she was awarded PhD by the National Law School of India University, Bangalore, in the subject International Taxation in Electronic Commerce. After practicing extensively before the Supreme Court, High Courts, tribunals, and other appellate fora, as well as the authority for advance rulings, she took up the position of Special Government Pleader, Taxes, Madras High Court in June 2014. She was later appointed permanent judge of the Madras High Court in October 2016. We welcome you to the session, ma'am. Our speaker for this session, Advocate Sujit Ghosh, specializes in tax, constitutional law, contracts, and energy law matters and is based in New Delhi. He qualified as a lawyer from the National Law School of India University, Bangalore, and has 25 years of experience as a tax lawyer. In the formative 15 years of his career, Sujit worked with Arthur and Anderson and Ernst and Young. He later enrolled with the Bar Council of India. In the last 10 years, Sujit has argued as lead counsel in several landmark decisions that have been rendered by high courts and several benches of Sestat across the country. He's a regular speaker at various industry fora and has been conferred with various accolades, including Tax Lawyer of the Year award by the Indian National Bar Association. I welcome you to the session, sir. Over to the chairman and the speaker.
Good evening to all of you. I hope my audio is clear.
Yes, ma'am, it's clear.
All right. First of all, thank you for this invitation to chair this session. It's a great pleasure to be with all of you. The topic for this session is emerging trends and challenges in taxation today. I think over the last 1 year, world economies have seen a great deal of turbulence. Of course, not just in terms of commercial activities, personally as well. Qua taxation, I'm not able to put a finger on any specific issue that would be a collateral of the pandemic itself, except, of course, the question of limitation. But limitation has been addressed by the Supreme Court in a series of judgments where they have taken cognizance of the difficulties faced and have extended interim protection till 31/1. And time for filing of statutory appeals has also been addressed by apex bodies such as the CBDT and the corresponding indirect tax body. So as far as limitation itself is concerned, I think things are well within control. Now, coming to emerging trends, I've had the benefit of the presentation that the speaker for the day, Mr. Ghosh, is proposing to share with all of you. And I think he's touching on some of the important emerging trends. From what I could see, he's going to be speaking to you about faceless assessments and appeals, equalization levy, the emerging trends in digital taxation. Of course, as far as digital taxation is concerned, it's not a novel occurrence today. We've had transactions that are becoming digital over the course of the last 1.5 decades or maybe more. I remember in 2005 when I submitted my thesis on the taxation of electronic commerce. Even then, India had set up a high-powered committee to look into this aspect. The OECD was very active even at that point in time. What is perhaps of relevance is the degree to which transactions have become digital today. Maybe where we had transactions that were 30 to 50% digital a decade or more ago, today we have transactions that are 80 to almost 100% that are digital. Especially modes of payments. You have cryptocurrency and bitcoins, and I'm sure Mr. Ghosh will be touching on these aspects in the course of his presentation. And of course, these are emerging trends. He's also touching on old demons such as retrospective amendments. So we will see that and hear his presentation shortly. I didn't want to touch on technical aspects, seeing as you're going to be seeing a presentation on those aspects soon. I thought I will share with you what little experience we have gained in terms of the challenges that we've had, bearing in mind the difficulties of the last year, COA taxation itself, which is essentially the conduct of proceedings over virtual courts. Now, the tax court is perhaps one of the courts that is best equipped to handle virtual proceedings. I remember about, again, this is not something new that we've done since last March. A pilot project was started pan-India and 3 courts were selected. I'm talking of about 15 years ago, when in Madras, the tax bench was headed by Justice Chitra Venkatraman, and the tax court in Madras was selected as one of the 3 courts to look at holding of virtual proceedings. And the bar at that time rose to the occasion, and all the tax case appeals and revisions, etc., were scanned. Everything was quite smooth. And the pilot did go on well, but unfortunately, it didn't take off as a trend. Now, fast forward to March of 2020, and it has come to be thrust on us. And as I said, tax courts are one of the better courts that are equipped to deal with this. If one were to compare it with, say, a bail court, which by the sheer volume that it has is simply unable to cope with virtual proceedings, at least finds it more difficult too. Or a court hearing civil matters where you would have complications such as recording of evidence, etc., which is a huge challenge. Now, when we commenced virtual hearings in March 2020, the first thing that we found was that a virtual court is a great leveler, perhaps one of the greatest levelers that we have had in litigation. And what I mean is that all of you would be aware that tax litigation is confined to small pockets of people in different locations of the country. But with the emergence of a virtual court, you have the opportunity and the possibility of people stationed in any corner of, why just India, but any corner of the world, that is able to see the virtual court as a stage to make their submissions before the court. And this is fantastic because you've got lawyers who have done original work before the assessing officer, who would be best equipped to handle the matters, best cognizant of the facts, who perhaps were not able to appear in a physical court because of limitations of travel and resources, etc., which have all now evaporated in the era of virtual courts. Now, courts all over rolled out a whole lot of standard operating procedures, rules and regulations. And that also is in line with your topic today, an emerging thing, because there were many things that we did not foresee when we first drafted and formulated the virtual video conferencing rules. For instance, to compare it, one says that any place where you sense the divine is a temple. Now we have a situation where any place where a council is becomes a court. I've had the interesting experience of finding a counsel who looked like he was moving through traffic. And when I asked him, counsel, are you driving? He says, yes, my lord, I'm on a 2-wheeler. And he was in fact holding a phone and arguing a matter. So then we had to say, please pull up to the side if you are very particular so that you are safe, and then argue it. So these are things that, these are interesting experiences that one has. And then we have had experiences where one simply forgets, and I'm talking about the arguing counsels, one simply forgets that wherever you are becomes a court, and you have to be suitably attired as well. So very casual attire is simply not acceptable. We have to prescribe a dress code for that. So these are some of the things that we have also become cognizant about while dealing with the issue of online hearings. On the aspect of limitation itself, though this may not be a direct offshoot of the last 1 year's events, we had a judgment of the Supreme Court rendered bang in the middle of the pandemic in May of 2020 in the case of Assistant Commissioner of Commercial Taxes versus GlaxoSmithKline, where a vexed issue relating to whether a writ court could entertain a challenge to an order of assessment or an appellate order beyond the period of limitation that is provided, where the limitation was fixed, was considered. Now, courts have been taking differing stands on this throughout. And in this judgment, the march of law has been examined, starting from Mafatlal and then Steel Authority of India. A whole lot of cases have been looked into. And the proposition has been reiterated clearly to say that when you're looking at a statute that provides only for a fixed limitation, then though the hands of the court in 226 are not tied, the path is very, very narrow for a court to be able to condone that delay and say that there is justifiable reason for the case of the petitioner to be accepted beyond the period of limitation that is fixed by statute. So I think over the last 6 months or so, we've dealt with a whole lot of writ petitions where this issue arose, and I had a batch that I had occasion to deal with, where I felt that now petitioners who approach court beyond the period of time that is fixed by statute have two roadblocks. In the sense that the first becomes relevant when you have to explain laches. And that, in my view, would have to be a very, very justifiable reason, and perhaps a human reason, perhaps a medical ground or some other ground to say that there is justification to approach this court beyond the statutorily fixed period of limitation. And then again, you have the plea of alternate remedy, which all assessees are well aware of. I won't take much more of your time at this juncture now. I'll hand you over to Mr. Ghosh for his presentation. I understand that he will be addressing us for a period of about an hour, after which we will throw the floor open for questions. Mr. Ghosh.
Thank you, ma'am. It's a pleasure to see you so relaxed in an environment which is all about academics. And thank you, all of you, for having invited me. And it's indeed a pleasure to be speaking on something very unique. When I got a call from the organizers, and I was actually scratching my brain in terms of what exactly should I talk about, because in the daily rush into court and out of court, many of these things don't necessarily come to our bent of mind or perspective, because we're dealing with fire, so to say. But issues relating to policy is something that needs to be appreciated with a calm sense of thinking, rather than holding a brief for any one client or the other. Yes, as Honorable Justice Suman rightly mentioned, that yes, there is a presentation that I have for you all. But before I upload the presentation, I also wanted to make a point or two on the virtual hearing that ma'am just made a reference to. I am a person who has immensely enjoyed virtual hearing. Not because of the thing that it has cut my travel time, but because it has given me good health. Because as counsels who are running from one high court to the other, you are almost on the wheel every other day, catching a flight or moving from one city to the other. And it takes a toll on lawyers because they have to be true to their profession as well and commitment to their clients. And virtual hearing has effectively helped us in delivering effective quality legal services without causing a dent to your lifestyle or your personal health. I hope and pray that pandemic goes away, but at the same time, I hope and pray that virtual hearing becomes the new normal. But the challenge is that while some high courts are continuing to have virtual hearing, there are many high courts that have opened up and they are insisting on physical hearings. So, and there is the third category of high courts which are getting into a hybrid model. So if you are a multi-high court lawyer or a multi-court lawyer, then unless everybody is on the same page, it still is not going to be as effective as virtual hearing as we had in the last 9 months. But it is an interesting and exciting phase of our career and phase of the legal Indian legal system. I wish it stays on. Anyway, coming back to the topic of discussion, I will upload a slide presentation. I hope I have access to share screen with all of you. Can I share my screen? Okay, just one sec. Like I said, technology and I don't see eye to eye. Give me a minute. I'm finding it a bit difficult. Just give me a minute. Okay.
Now you realize, Sujit, one of the difficulties in virtual hearing,
I can
technology.
imagine, ma'am. I can imagine. Okay. So these are the things that I'm going to talk about. As ma'am rightly mentioned, digital taxation, equalization levy, cryptocurrency, then faceless assessment, and so on and so forth. Now, what I want to tell you all as a perspective, there's a very interesting book by one gentleman by the name Friedman. The world is flat. If there is a flutter that happens in Amazon, jungles, it could potentially give rise to a tsunami somewhere in the Far East. Our economies and economies of the West or economies of the Far East are also intertwined that you cannot look at geographical boundaries in the strictest classical sense as a means to exercise your sovereign right to harvest tax. So, tax administrators in the recent times have found it extremely difficult to manage a means to tax transactions which have no boundaries. And globalization and technology has kind of taken it to a zenith where the existing tax codes have oftentimes failed. And every country which kind of depends significantly on tax revenue as its source of growth and economic development and whatever you may have, has tried to find out ways and means to tackle that. So what we have seen in the last 15 years is a new phenomena of taxation of digital economy. Faceless assessment is not so much about harvesting of tax, but it is essentially about administering the tax regime. The pros and cons of that is something that is still being debated, and we'll talk about that. But aside of these imperatives, what we have also noticed, and more so in the last 5 years, of course, this has been there for several years, and in the income tax laws, we have seen oftentimes retrospective amendments happen. But in the last 5 years, after GST has come into force, we seem to notice a trend, increasing and a difficult trend, a not so happy trend of overturning the status quo. which is in the form of retrospective amendments. How far are they correct? How far are they pragmatic? How far do they meet the test of canon of certainty? All of that is something that we will discuss. So that's the background within which we have tried to frame this presentation, and let's see whether you are able to enjoy that or not. So the one of the most important reports that you can lay your hands on is this OECD report of 2019. What they have been noticing and looking at economies all across is that jurisdiction of a company, a jurisdiction to impose tax of a company, is not necessarily going to be confined to the physical boundaries of brick and mortar transactions as we have often seen. So economic activities are actually becoming faceless and sans jurisdiction. You could have somebody sitting in the US and doing as much business in India or in Japan without there being any nexus or any residence or establishment in those local jurisdictions. So businesses with physical presence oftentimes, and this is base economic principle, that if you have a manufacturing facility, you create other means of economic growth in terms of employment, labor, man and machine, other cluster growth areas that kind of happen around that, each of which generate taxes by themselves. So if you have a factory and you have an ancillary also generates taxes. So there are the citus based economic development has generated a ripple effect of tax collection potential for governments. But when the citus itself is missing, somebody is transacting based out of the UK with customers located in India and in great deal, multi-billion dollars and over a period of time, even forget about collection of tax directly in respect of those transactions, the ripple effect of those transactions to the larger kitty of the consolidated fund of India in terms of revenue collection or economic growth does not even happen. So digitization of business has led to significant loss of public exchequer, whether directly or indirectly. Now, as we often know of, law in India especially has always been the lag law. In other words, law tries to catch up with the changing milieu of the economic development. So the transfer pricing law came much after transactions were happening where there was some kind of a base erosion. Okay, the GST law happened much after there was distortion that we found in the economy. So the Indian legislative regime of tax policy making has always been a lag law. And in your desire to circumvent that and move from a lag law to a lead law concept, where you're effectively saying that the law will catch up and be ahead of the economy, this concept of digital taxation can be touted as one significant development. Okay, what they're trying to do is they're pooling the experience of digital economy across the globe, at least in the OECD countries, and trying to frame a common market, a common network, or a common policy of how those transactions will have to be taxed. What has also been found is that data and synergies with the intellectual property, these are all customer specific. For example, take a WhatsApp. You have a WhatsApp arrangement where you send messages free of charge. Little do you realize that as you do that, your data, your profiling, what you like, what you don't like, for that matter, if you go to Facebook, you will be surprised to note that depending upon where you actually had your last dinner or the kind of cuisine that you had, Facebook or Google will keep throwing those as tailor-made offerings for you. So the bunch of data collection that is happening in this digital economy or digitization of business, where the data itself becomes an intellectual property, and that becomes something that is acquired by some of these portals by whatever name called, and that information, whether you like it or not, is being sold in the market to a willing buyer who is going to use this data to penetrate back into the market from where the data was collected. And how do you value that data? Because that data is enormous. How does anybody know that a council by the name so and so sitting in Delhi loves to have coffee at this particular brand? And if he gets to know about my choice, then of course he will be able to pump in advertisement relating to that kind of product every now and then, such that I'm going to be a prey to that advertisement and go and purchase that online. So there is a significant amount of data collection that happens that itself is an asset and with a significant value, which that is getting transacted, sold to third parties. And therefore, that becomes a significant source from where the tax revenue could have been collected, but they can't do that because there is no framework to do so. And interestingly, this value of customer base is something that you will not find sitting in the balance sheet. Nobody accounts for in their books to say that I have access to Indian market, the middle class in India, and that market, the value of the customers or the number of customers and the data point of that is something that I will not record, even though it is intangible. I will not record in my balance sheet. And since it is not in the balance sheet, it is kind of hidden somewhere. It is therefore not capable of ascertainment from an assessment of tax perspective, even if you may have had a machinery. Okay, so the whole concept of digital economy is it is elusive. It is in thin air. It is not something which is easy to access like your brick and mortar economy, and that makes it that much difficult. From a Indian tax perspective, one of the fundamentals have always been nexus theory, the nexus of a taxable event with the charge of tax, nexus with a taxable event with the jurisdiction or the country where the nexus is created. But in a digital economy, the nexus need not necessarily be qua the service provider or the provision of their activity. It could be in the form of the customer who may be located in India. And the rules of engagement, and I will come to digital taxation in terms of equalization levy a little while from now. There have been a great deal of debate before the Indian income tax authorities when you are trying to tax e-commerce. Okay, because the fundamentals of income tax is very clear. If you are a non-resident doing business in India, you will be taxed as a business income provided you create a PE. No PE, no tax. That's a basic fundamental, something that anybody who gets into income tax gets to learn. And all of these companies had never had any establishment in India, never created a PE in India. Resultant, it was a business income. Resultant, there was no question of any levy of tax. Tax authorities didn't like it, and they started jumping around, and they said, oh, fair enough, if you say if it's not a business income, I will treat it as a royalty or a fees for technical services. And look what, you have not deducted tax on those transactions, and therefore I will deny you the expense. The moment you deny the expense, it becomes a significant cost for you, and therefore you get into litigation, and then you go to court, and the tribunals have been holding. I think Yahoo is a very interesting decision, and there's another judgment, another tribunal decision in the case of some florists, I recall, where the tribunals have said, sorry, this is not a fees for technical services, nor is it royalty. It is in the nature of business income, and therefore you don't have an AP. And since you don't have an AP, the question of imposition of income tax or denial of the expense does not even arise. And the moment that happened, the doors of the revenue to collect tax on the digital transactions went away. Of course, the revenue is litigating that. The matters are now before the Supreme Court, having traveled from the ITAT, etc. But then they still hold a position that these are fees for technical services. But in the interim, they had to devolve some kind of a mechanism to be able to tax it willy-nilly, some way or the other. Okay, and so the complexity of digital taxation is not because the government wants it desperately, but it is the need of the hour, because there's a significant amount of revenue that is getting generated through consumption of services, consumption of goods, consumption of value additions that is happening on the Indian territory. Okay, so therefore there is an economic rationale for this particular tax. It is not as arbitrary as window tax that Belgium saw at one point in time. It is not as arbitrary as that. There is some amount of sense, there is some amount of urgency, there is some amount of need from a sovereign's right to collect and a command tax, and therefore that temporal justification can certainly be traced. Now, then there is this concept of multi-sided businesses. I have already spoken about it, the WhatsApp thing. So they collect the data from you, and then they trade the data with third parties. You may think that WhatsApp services are free. Actually, it is probably a barter, because you give them the data, they're giving you free services. And mind you, in some jurisdictions, WhatsApp services are taxable, are chargeable. So economies which they are very interested in, such as India and the larger economies, the growing economies and the Asian tigers, as we call it, maybe it is free. So these are all tactical means to get penetration in the local market insofar as data is concerned. Okay, so multinational negotiations have happened at the OECD level and the G20 level. in respect of treatment of digital transactions, and the BEPS Action 1 pertains to digital taxation. And BEPS Action 1 is actually the foundation or the edifice on the basis of which equalization levy was thought of. So 2016 equalization levy was brought in. Now, I don't want to get into the nuances of equalization levy. That is not the purpose. This is not a discussion on equalization levy per se. But there are some very important thoughts that needs to be kept in mind. The need for equalization levy was, to my mind, a desperate attempt of the revenue or the government of India to tax a transaction which was escaping because it was not qualifying as fees for technical services. So on the one hand, the government of India is litigating, saying that it is a fees for technical services or a royalty, and they are before the Supreme Court. And at the same time, they create a new chapter through a finance act and imposes equalization levy. The interesting point to be noted is that it is not an income tax because it was not brought out as an amendment to the Income Tax Act. It was created just as Finance Act 1994 created service tax. It was created as a separate charge of tax. Now, the power that a government or a union government can have to justify a levy is so wide that entry 97 list 1 gives them almost the right to tax anything or justify any levy, so long as it does not encroach upon list 2 or list 3, which is state and the concurrent list. And entry 82, if I recall right, is the entry on which income tax is levied, and entry 97 can be the basis on which equalization levy can be justified. Okay, but there are some very interesting issues that comes about, which I'll talk about shortly from now. What they did was, when they initiated equalization levy in 2016, they kept it on very few transactions. We had anticipated in 2016, and in fact I had written an article long back, and I was just going through my notes this morning. We had raised a concern that while you may have introduced the levy on a very small number of activities, what stops you from making it expansive tomorrow? What stops it in such a manner that you are actually levying tax on services of all kinds? Because today the constitution actually defines the services to mean anything other than goods. So what stops you from increasing it? Just as you increase the ambit of service tax initially in 1994, which was restricted to 4 services, insurance being one of them, if I recall right. Okay, and then from there it went to about 97, 99, or maybe 100 plus services that you taxed until it was abrogated by the 2012 negative list regime, by which time you kind of made it all pervasive. So you as they say in economics, you give them a bigger shock, they'll succumb to the smaller one. So you give them a bigger shock in terms of this equalization levy, they succumb to that, and they were okay with the 2-line entries, and then slowly you're doing a creeping incremental imposition by adding more services. And 2020 the government of India brought in far more number of services into the net of equalization levy. So it was an initially thought to be taxed only on digital advertisement, and that is where the genesis was. Now, today in 2020, it is levied on online sale of goods through e-commerce operators, online provision of services, any combination of these. It is so the whole sector of e-commerce has been brought into the net of tax, which, by the way, is a significant revenue generator. Okay, digital advertisement was just one part of that, but digital advertisement leading to digital sale of commerce or supply of commerce was the consequential revenue generation for businesses, and therefore that larger aspect has been brought into tax, which is a significant one. What has happened is the rate of tax may have come down from 6% to 2%, but then it is still there, and with a wider base they're able to probably justify the revenue collection even though with a drop in the rate of tax. Okay, now what is important, and I'm going to skip this detail, is what is important, as all of you are chartered accountants, most of you are chartered accountants, and some of you may be lawyers here, is whenever a new law comes, a new levy comes, some very ticklish questions do often plague our mind. Like I said, is it a tax on income? If you see the sweep of the legislation kind of operates on the plank of the Income Tax Act. Almost about 20 to 30 provisions and a certain section on tax administration, including appellate provisions, have kind of been borrowed from the Income Tax Act. Okay, so it has the crutches of an income tax, but it doesn't use the word income. Okay, it doesn't use the word income. It is not being made incorporated into the income tax act. So therefore, the government stands up and says, look, it is not an income tax. So therefore, this is something that is different from that, even though administration of that may be done under the income tax act. But then the next question is it a tax on services or a supply? Because the charge of tax on equalization levy is on the consideration received for provision of specified services. How much more glaring can it get that the charge of tax is on provision of services? And if the charge of tax is on provision of services, then services was anywhere subject to service tax under 1997 or 92C. Okay, and therefore to bring in another levy in the form of equalization levy, were you not levying services in a different manner? Okay, and you have to also keep in mind that under the GST regime, which is 246A, 36012A, it's a tax on supply of services as much it is supply of goods. So therefore, and there is a concurrent power available with the state governments now to levy tax on the same transaction. So what is happening interestingly is that you call it as a tax on a specified services. In effect, perhaps it is a tax on services or supply of services, which used to be liable to service tax, which is now liable to GST. And consideration is nothing but top line. It is a gross amount charged. Okay, so top line is the base on which the levy is, and if it has all the essential features that makes a transaction liable to a service tax or a VAT in the international world, or a GST in the Indian context. Then the next question comes out is it therefore a double taxation? Now, double taxation is a utopian concept, right? Because there is nothing called double taxation. Okay, unless of course you're talking about the treaty kind of situation where the same transaction is getting taxed by two countries. A double taxation in India is, the Article 265 does not prohibit double taxation. So if anybody were to say that having paid service tax, why should I pay an equalization levy? Because e-commerce transactions are liable to service tax, are liable to GST as well. So if you stand up and say, having paid service tax, why should I pay equalization levy? The courts will tell you who stops the parliament to impose two taxes. Who stops? Tell me which provision, Article 265, says that double taxation is prohibited. Okay, so double taxation cannot or will probably not be a defense to assail the levy, because 265 does not prohibit that. But then there is another important aspect, which is the doctrine of colorable device. Now, levy of tax on advertisement is a state subject. Levy of tax on advertisement is a state subject. And if that be the case, if you are levying equalization levy on provision of advertisement services, is it not indirectly a tax on advertisement? And if you are able to satisfy yes it is, then it is a colorable device, what you could not have done directly by taxing advertisement. In the garb of levying an equalization levy, you brought in this particular piece of legislation using the cover of 1997. So that could be one way of looking at it. uh, Two judgments I've quoted on there is no bar of double taxation, and the one of Privy Council that you have, 1945, is the Bible, and every other judgments have kind of followed it to say that you cannot say that double taxation is unethical, or it is illegal, or is contrary to the Government of India Act then, or the Constitution in today's concept. But a ray of hope that has also come out from the Supreme Court is the concept of defense of aspect theory. So if anybody is able to satisfy the court to say that, okay, if the same aspect is getting taxed twice over, okay, and legislative competence of one of them can be said to have been breached, then by application of the aspect theory, you can say that equalization levy and service tax or GST cannot go hand in hand. And the question, and the most difficult question, therefore, that comes to be that kind of provokes our thinking, is that is there any two aspect to this particular transaction? Can you say that in a digital taxation, in the manner of equalization levy, or a service tax, or a GST on e-commerce transaction, import of e-commerce transaction, there are two separate aspects? Unfortunately, or fortunately, depending upon which side of the frame we are, the legislation of equalization levy does not make any mention of what aspect it seeks to tax, other than saying it's a tax on consideration for provision of services. And if that be the case, there is only one aspect, which is the provision of services, that I can think of. Unlike an entertainment tax, and service tax, because entertainment tax and service tax, many high courts have had a view on that. Madras High Court has had a view on that. Tripura High Court had a view on that, and several Delhi High Court had a view on that, to say that okay, when you watch a DTH program on your television, there is a service element, no doubt, because you're taking the DTH services, but there is also an entertainment element because you are getting entertained as you watch the movie. Okay, so there is an entertainment angle. The aspect of entertainment is what is being sought to be taxed. Aspect of service is not necessarily what is to be taxed, and therefore you cannot say that there is an encroachment into the state's domain. And by applying the same logic, I seek to ask this question to all of us, that in a provision of services, which is the taxable event for levy of equalization levy, what is the aspect that the government wants to tax? Is the aspect a digital economy? Well, that can't be an aspect. Digital economy is the very edifice of the nature of the environment. It is not an aspect. The aspect that has to be ascertained has to always to be aspect where the consumer of the services, or the consumer of the beneficiary, or the beneficiary. That is the only short way to find out the aspect. For example, when the Supreme Court was looking into the distinction between goods and services qua SIM card, it was being viewed in the context of the beneficiary. Okay, it was goods because it was being traded, i.e. the beneficiary could pass it on, title to transfer could happen, it could change hands from one to the other for a consideration, and it was the telecom service receiver who was receiving the services, and therefore there was a service element of that. So the relevance of an aspect theory will have to be always looked from the perspective and prism of the service recipient, and not from the revenues point of view or the government of India's point of view. And if I so choose to look at it, then I see no different aspect. It is only the service. I, as a consumer who buys books or services from Amazon, okay, I am receiving a service because that is a mode of delivery. That is a mode of delivery. I could have stood in the queue and gone to a good old bookstore at the corner shop. Instead of that, I choose to receive it through the electronic means, and that is a mode of delivery. But it is as much a service delivery as it can ever get. So therefore, the moral right to call it a service and impose a service tax or GST that you exercised many years back, what happened to that moral right? Why do you now say that no, that is not the aspect that I'm seeking to tax, I'm seeking to tax something else? So great lot of debate will be there in times to come, because as the tax gathers teeth, and as people who are subjecting to this tax as are not able to bear it, it breaches that threshold, matters will come to the court for consideration. Now keep in mind one very important point. By virtue of the fact that this is not part of the Income Tax Act, your section 90 benefit, which is the treaty benefits, do not apply. Curiously, about 15 or 20 provisions of the Income Tax Act was borrowed, but section 4, section 9, section 90 has not been borrowed. Very clearly, therefore, saying that withholding or the tax that has to be paid by way of a deduction under the equalization levy is not going to be creditable in the home country, and therefore it's a double cost to carrying on business. Okay. Now, as soon as equalization levy was imposed, US trade representatives launched an investigation against India. Okay, they were not very happy about this fact. They felt that what this levy seeks to do is to target the US large giants who are digital companies providing digital services. They said that additional annual burden on the US companies went up about $30 million per year, which is a sizable amount. And they kept on howling that extraterritorial implication. You're trying to come to US to levy tax on that. But that extraterritorial as a logic is completely fails, because 245(2) Constitution very clearly says that no law can be said to be bad in law just because it has a extraterritorial effect. So therefore, that was at a diplomatic country-to-country discussion that was happening in November 2020. The last of the discussions have happened. The government of India has justified that by saying that, look, it is not unfair because it used to be 6%, we have brought it down to 2%, and it is on all non-resident, whether it is from US or from Brazil or from Bangladesh. How do I care? I have not said that it is in relation to imports of services from US. Okay, it says that there is a nexus with India because of the market. Okay, the purpose is to tax business having nexus with the Indian market. So it is not that I'm charging a tax on somebody who does not even talk to Indian customers. What is also important is when France did something very similar, they came out with called a French digital service tax (DST). Okay, now this coinage of the word French digital service tax is very important to justify the very essence of this tax. It is effectively a tax on services. It is a service tax, and this is what France calls it. And if that is the case, and that is the international jurisprudence on the nature of tax in India as well, you may call it as you may call rose lotus from tomorrow, but that doesn't make lotus any less a rose as it used to be. And by that same logic, if France has been calling it a digital service tax, in a sense, perhaps it is in the nature of service tax, because these words get coined by the OECD country members, and India kind of borrows that concept in many ways. So when France came out with digital service tax, US announced imposition of 25% tariff on the French imports into US, and suddenly, okay, this started on January 2021, which is about 2 months back. Suddenly and thereafter, France has kind of suspended the imposition of this DST as they introduced. So what is happening is, yes, sovereign control and sovereign reverence that you may have, or justification that you may have to justify an imposition. You can cry horse and go to the parliament and say, thump your chest and say, yes, I have the right to levy tax, I have legislated. But your ability to implement that becomes a suspect as soon as you get a pushback from the international market. And bilateral discussions happen, and trade embargoes are imposed in some way or the other. France has succumbed. Let us see how India deals with it as the discussion starts happening, because the last of the discussion that happened with the US was in November 2020. Much needs to be seen in terms of what will kind of pan out in the coming times. Okay, so the way forward, as I can put it, is they are likely to drop equalization levy on e-commerce when global consensus builds up. Like I said, I can see that coming because of the pressure from the intergovernment negotiations that are going on, because the tech giants are not going to let it go in that manner. The rules that are in existence today is not adequate to tax digital transactions and address concerns around profit erosion, because much work is going on the base erosion and profit shifting, and that will have to be taken note of. Global consensus is key to sustainable and fair tax system, because there is no consensus, so to say, because the producers of these services are on the one side, the consumers, the Asian tigers, and the market economies are on the other side. So they will always be at loggerheads, and their purposes will not necessarily be aligned. India is working closely with the G20 and the BRICS in this regard, but we'll have to see how it kind of develops. Logistics required to be more comprehensively formulated. This logistics is more to do with the data capturing and the value creation and value trapping and all of those things. As we have seen in the US, unilateral steps have not been well received, and therefore many countries are begging for a discussion before they can continue with this conversation about imposition of levies of this kind. India is also in the midst of that. Issues such as double taxation also needs to be addressed. Now, let me pause here for a minute and tell you, what is this double taxation about? See, double taxation is a theory that let a person not be penalized twice over to two different sovereigns for the same income that he generates. Okay, there is no inherent right that you can claim, but it is an equitable way of asking governments to kind of make a largesse. And this equitable largesse that you call for has had the effect of creating a treaty between nations to say, fair enough, to this extent I shall have the proprietary, I shall not do a tax on the same transaction on which you are levying tax in your jurisdiction. So to avoid the same transaction to be taxed by two different sovereigns, it was felt at an international league of nations, between the committee of nations, to maintain some kind of a harmony, balance of trade, or whatever else you can talk about, that the governments coined this concept of no double taxation and double taxation avoidance. If there was no treaty, nobody would have had the right to ask for such a largesse. And your section 90, which is predicated on Article 253 of the Constitution, read with Article 51 of the Constitution, which talks about respect to international treaties. 253 talks about treaties to be implemented through legislations. All of that was needed because the government to government conversation was such that they said, okay, fine, I'll give you a largesse. But that does not mean that you can come out with a equalization levy as a means to bypass that and indirectly try to tax it again. And the moment that happens, the morality of taxation, which is oftentimes the most vexed issue, a conversation between a bilateral conversation between two countries, the morality of taxation comes into to say that, are you being fair? And it is for the domestic or municipal legislation at that point in time, legislators at this point, at the government to government level, to stand up and say, yes, it is fair because we need it, or yes, it is not fair, give and take. So such conversation of double taxation is something what is going on perhaps behind the curtain, and we don't know about it. And that will have to be addressed necessarily by some other route, and not necessarily through Section 90 of the Income Tax Act or read with Article 253. Okay, so keep that in mind. It's a work in progress for the government, and I'm assuming that the pressures that the other economies are putting onto India and the likes will probably yield, as we saw in the French case as well. Cryptocurrency, it's something very, very interesting. It is something that caught our attention in the last 3-4 years, and until 3-4 years back we didn't even know what was bitcoins or whatever, by whatever name they are called. But fundamentally, when it started erupting in India, just for the sake of your understanding and appreciation, RBI banned it. Okay, they said cryptocurrency trading in India will not happen. At the end of the day, cryptocurrency is centralized. It's not a centralized thing. It's a decentralized currency, if you may call it. It's a parallel economy, you may call it. It's instead of the tenders in the form of notes or rupees or dollars that we're talking about, which kind of binds economy, a very parallel system of coins, you can call it, or whatever units you may call it, which has been created through the concept of blockchain, which becomes a currency which can be used to buy and sell services. Okay, it's a parallel economy in many ways. That the essence of cryptocurrency is that it can be used only once. Okay, so if you have acquired cryptocurrency from a source or a mine, as they call it, so the miner brings out the program through which the currency or the cryptocurrency is kind of identified through a certain ID. That coin then gets made available in the market, and you can only use it once. But you can also trade in that. Okay, so cryptocurrency has dual usage in that sense. One is it can be used as a currency. Okay. Two, it can be used in the trade where it is actually bought and sold at a premium in the market. Okay, so Reserve Bank of India felt threatened that if this is going to take off and create a parallel economy in India, what will happen to the one rupee note legal tender that the government of India generates, and therefore the whole economy is going to be
Sir,
going to crash.
sir, if you can conclude in next 2 to 3 minutes, we would probably request the chairman to speak, and then we could have question and answer at the end.
Sure, sure, sure. I'm so sorry. I didn't even realize that I finished my time. I'm so sorry. Thanks, you kind of reminded me. So cryptocurrency has brought about a fundamental shift in the thinking process. The
Can
Supreme
I
Court.
take a moment? Sujit, you're more than welcome to take my time as well.
No, 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 ma'am.
No,
People want to hear you. People want to hear you.
no. Because they might want to hear the technical aspects of what you have to say on what's remaining on the retrospective amendments as well. So,
Sure, sure. I'll probably okay. I'll make a point on cryptocurrency and come straight away to retrospective amendments. Yeah. So cryptocurrency has been frowned upon by the government, but the Supreme Court has cleared it, and the RBI is now has tabled a new legislation, or the Parliament. It's a bill called the Regulation of Official Digital Currency Bill. Now, as the bill gets passed, there will be a regulation governing cryptocurrency, and as and when it happens, there'll be some very interesting vexed issue on taxation of that. Will it be treated as akin to money, in which case of course it will not bear any tax, but to the extent it is traded in the market, it could be treated as an asset, it could be treated as a property, and therefore there could be GST, there could be a capital gains, there could be a short-term capital gains, long-term capital gains, business income, the whole 9 yards of taxation comes into being to the extent it is being traded. So there is a great lot of interesting development that we are watching out on this space, and in times to come, it'll all come out clearly. I'll quickly skip all of this and come to retrospective. Faceless, I will move because it will have required me some amount of time. So retrospective amendments, and I have some serious concerns with the retrospective amendment that has happened. Ideally speaking, I'll come to this concept, the Buckingham case. Ideally speaking, retrospective amendment is to take care of what is called small repairs of inadvertent defects in statutes. Okay, unintentional mistakes that may have crept in. is to be undone by way of a retroactive or retrospective legislation. Okay, that is the real essence why sovereigns exercise this absolute power and inherent power to legislate not only prospectively but also retrospectively. But what has come by is that it is a way that is being used by the legislative wing of the government to exercise supremacy over the judicial wing of the government. Okay, because the fundamentals are very clear. We have a separation of power. Judiciary does not declare the law, it only interprets the law. That is one way of looking at it. But then, having interpreted the law, sovereign has every right to say, okay, this that was the interpretation of law, I am undoing it, and I can do so in the past, going back in time. So the essence of inadvertent defects or small repairs, which was the genesis of retrospective legislation, to my mind, has been completely given a go by, and the whole exercise is to undo what the judiciary has done, such that nothing but harvesting of revenue is the driver. The canon of certainty or the canon of uniformity, that is a fundamental of a tax law, completely takes a backseat. Now, two very important things comes out based on the US decision in the case of Dhoni's case and then Sunburst's case, where the doctrine of prospective overruling was introduced in the US legislation. I think Justice Marshall was the judge, if I recall right. That was adopted in India as well, in Gulaknath's case and several others thereafter, where the Supreme Court said we need to preserve the past and protect the future. And that is why they came out with prospective overruling as a concept, that it will create a disaster to the economy if I go back in time and undo something that may have happened for the last 30 years, because our judgment of Supreme Court goes back in time. So if the Supreme Court can come out with such a beneficial concept of prospective overruling as a way to preserve the economy, must the sovereign, must the legislature use a retrospective legislation as a tool to disrupt the economy? And it actually has an effect on the faith and fidelity that SSCs have to the laws that are in force at that point in time. You ordain your business based on the law that it exists today. You have a full faith and fidelity to that particular law. You are willing to face the consequences of that. And suddenly 10 years later or 5 years later, you are told, sorry, what you did was not what the law was, because I am going back in time 30 years. So therefore, the very faith and fidelity of a legislation, which kind of gives a moral justification of a legislation to be accepted by the citizenry, comes into great question. And then there is this other concept of what is called a temporal limits of constitutional governance. A temporal limit of a constitutional governance would essentially mean that you are elected for 5 years, let's say from 2000 to 2005. Okay, can you, with the mandate that you have in 2020, 2020 to 2025, can you, with the mandate of 2020, frown upon and question a legislative decision taken by a party in power in 1975, when they came into power based on the mandate that people gave them? Where is your temporal limit? Can you actually go back and access in time that even though you were not elected by the exercise of franchise by people of India or citizen of India, you're actually unturning a decision which was taken by a party which was given the mandate by the people of India? So there are a great lot of issues in that, and because of paucity of time, I probably will not. But short point that I want to make is my concluding point, that yes, harvesting tax is an inherent part of your sovereign right. You cannot put a question to that. States' power in terms of who to tax and what to tax are not justiciable, no doubt about that. Administrative machinery failing in revenue harvestation can always be overloaded, no doubt about that. Law must march with the developing reality, thus they have to be dynamic, no difficulty. Crudities and iniquities in taxes is never a defense, no difficulty with that. But legislative competence and doctrine of dynamic interpretation is very essential. Unfortunately, I will not be able to spend time on dynamic interpretation. I would have loved to do that, but please do keep in mind that in today's time, the only way to deal with Article 14 and 19 1G issues is to apply dynamic interpretation. It is a subject in itself, and it needs to be appreciated. Doctrine of pith and substance is very important, and rule against colorable device. Testing times are there for the courts when some of these legislations are going to come before them for judicial review. Doctrine of natural justice and rule against bias. This was essentially in the context of faceless assessment, etc. Unfortunately, I didn't have the time to cover it. And then canon of certainty, preserving the past and protecting the future. Fidelity of law in force on the date of transaction and temporal limits. These are the things that I thought I will leave with you, and happy to take questions after Madam makes her presentation or speech. Thank you all.
Thank you for a Thank you for a very seamless and fluent and clear presentation. I only wish you had been able to uh, take us through the aspects of faceless assessment and appeals as well, particularly seeing as the delegates here would be very, very concerned with the new procedures that are in place. But that's for another day then. Just very, very few observations before we throw the floor open. And we'll start with the last aspect of what you said first, which is on the aspect of taxation of cryptocurrency. There's a great deal of lack of clarity or gray areas in what exactly bitcoins and cryptocurrency are. And for the interest of the delegates, you might perhaps want to read the judgment of three judges in Internet and Mobile Association of India versus Reserve Bank of India, three judges of our Supreme Court. This judgment is authored by Justice V. Ramasubramaniam. In his inimitable style, he has given us the entire background of what constitutes cryptocurrency. It's available on Indian Qanun itself. Writ petition civil number 528 of 2018. And the circular of the Reserve Bank of India that Mr. Ghosh referred to has in fact been quashed, and the bank has been directed to refund the entire amount of funds that stood in the account of that petitioner, which was harvested as cryptocurrency. So that's for just, we have a great deal of paucity on time, so I'm just touching on that, adding whatever I thought would add value to what has already been said. On the aspect of equalization levy, there were a lot of interesting observations on the interplay between aspects of taxation, aspects of privacy. And on the aspect theory itself, one interesting decision that you may want to look in is the Supreme Court judgment in state of Karnataka versus drive-in enterprises. State of Karnataka versus drive-in enterprises, which looks into again whether entertainment tax would be leviable on vehicles that drive into a theater to watch a movie. So the Supreme Court makes, in conclusion, they say that the argument that was put forth there was that it's a tax on the vehicle. And they say, no, there is a certain value that is attachable to this, because you have to contradistinguish a person who sits inside the vehicle, has the luxury of sitting in the vehicle and watching a film, rather than a squatter who sits alongside the vehicle, perhaps on an uncomfortable chair outside. So that's an interesting observation that was made that may have some relevance to this. Of course, Mr. Ghosh assures us that the levy is going to go away. But till then, we can continue to hypothesize. And one or two questions, I'll just flag off the question answer session with one or two questions that just occurred to me. He was talking about the relevance of Section 90, but then equalization levy is not under the Income Tax Act itself. And Section 90 talks about a levy under the tax and one under the double taxation avoidance agreement. So whether 90 would apply would be moot. And then again, that would take us to whether a tax credit would be given for a transaction, because again, this is not a transaction that comes within the ambit of the Act itself. Any thoughts on that?
So Section 90 will not apply. Like I said, they have borrowed two reasons why it will not apply, because it is not an amendment to the Income Tax Act. It's a separate chapter under the Finance Act. That is one thing. Second, they have borrowed specific legislative intent, certain provisions of the Income Tax Act, and Section 90 is missing. So it is also not a withholding tax, because the whole chapter on recovery of tax, that whole chapter A, B, C, BB, none of those have been borrowed. Only the assessee in default, that provision has been borrowed. So clearly it is not a tax deduction, nor is it subject to a tax credit or benefit under Section 90. And therefore it is an independent transaction or independent levy. And because if they had made it part of Section 90, then it would have been of no use. Government wouldn't have got any benefit out of that. So it is completely outside.
That would render the provisions of tax credit under treaty also would become
negative. Correct.
Any other questions?
Yeah, there is one question which is on recent budget proposal on doing away with the GST audit. Would that really help in bringing the ease of doing business and reducing the compliance cost and avoid litigation? Any thoughts?
Anything in GST is likely to have problem. So I don't think, I mean, subject to what ma'am has to say, my view is that what the government has done, and at least what the CA fraternity feels aggrieved, is that their involvement in the whole certification of the statement has been done away with. In one way, the government is trying to make it easier for businesses to carry on rather than get into muddled into multiple certifications through an external third party. So I think the purpose is very clear, but if in effect, it has actually excluded the chartered accountant community in carrying out that compulsory certification of accounts. That's where it is.
There's there's one more question, which is on section 17.5. The obligation of cascading effect of taxes being one of the primary objective of constitutional amendment enabling GST law enactment. Is section 17.5, in your view, is the biggest letdown to the citizens whom a very rosy picture was shown at the beginning, and it is misleading and a step by the government to deny the bona fide credit with special relevance to real estate sector?
Ah, I think let ma'am answer because my views are very clear on this, and I have some very serious views on that. Let ma'am give her view, and then I will make
May
my.
not be very appropriate to speak on technical issues, particularly
Okay.
because I'm sitting on the tax board.
Okay. So let me give my views on that. I think the trade-off that was told to the nation and the citizenry were brought into this tax was, we are going to increase the tax, but your credit basket is going to soon is going to grow and it's going to be significant. We had at that point in time when the policy was getting crafted and designed, oftentimes spoken to them that credit is at the heart of GST, and if you're going to tamper with credit, if you're going to make it restrictive in many ways, then the whole system is going to crash. They had assured us that they will not do so. But when we saw section 17.5, they have created those blocked credit as a concept, and many of those provisions, to my mind, are arbitrary. I'll take one simple example. What is the reason why plant and machinery definition excludes telecom tower? I'm just simple example. Plant and machinery, you get the credit, but plant and machinery excludes telecom towers. Why? Why do you include a power transmission tower? So power transmission tower is good enough to be a plant and machinery, but telecom towers you want to exclude. Why is it that long distance pipelines are not plant and machinery, but pipelines within the factories are plant and machinery? So several artificial distinctions have been carved out solely for reasons of revenue consideration. Okay, this denial of credit to works contractors, which is 17.5D, C, that is hotly debated, and Odisha High Court judgment and several other courts, those matters, it is purely because there's significant amount of credit that goes into some of this construction which the government doesn't want to let go of. So I am not too happy about this whole construct, but policy decision, unless 14 can be shown, will get sustained.
I'll go to the next question, which is the recent proposed retrospective budget amendment of sections 7, trumping the recent judgment of Honorable Supreme Court in Calcutta Club, is justifiable as it imposes a new liability on taxpayers who have applied principles of mutuality.
Like I said, it this whole concept of retrospective legislation is actually biting us and snapping at our heels. Every good decision that comes from the Supreme Court gets overturned subsequently. It is probably a way that the legislature is trying to trump over the judicial dicta and reinforce what they intended to be. And we saw that as old in indirect taxes, the ITC judgment, the cigarette judgment malvaluation, ITC won at the Supreme Court, yet they came out with a retrospective legislation. Vodafone, another example, where they brought out a retrospective legislation. They have won as per the treaty related investment treaty, that agreement. They won there, and the government now wants to file an appeal against that. So morality of such legislations are questionable. Correctness of that probably is not questionable in the teeth of law, on the basis of law, unless two things are satisfied: a, that it is actually malified, which probably you will not be able to satisfy, or it is confiscatory in nature. And to be able to justify that a retrospective legislation is confiscatory in nature, a great deal of data points are required for the courts to appreciate. A judicial review of such things becomes very, very arduous and difficult. There are very limited parameters available to get into what is confiscatory, what is not. The decision of Supreme Court in RC Tobacco is something that you should read, where they kind of lay down the parameter. much can be garnered out of that.
With a positive time, if you can conclude this in 1 or 2 minutes.
Yes.
Yeah.
It's been a pleasure being here. It's been a very, very informative session with Mr. Ghosh. I'd like to thank the association for this invitation again, and best wishes for the rest of the conference. Thank you very much.
Thank you. Thank you, ma'am. Nice and privileged to be with you. Thank you very much.
It's my pleasure, Sajid.
With this, I'll formally put the vote of thanks of the fifth session of the 33rd annual conference of KSCAA. I would profoundly acknowledge the fact that some of the concepts which were in depth requires more time and would probably would involve the speakers in the next conferences in the programs of Karnataka CA associations. Some of those concepts of digital taxation, equalization levy, virtual hearing, or retrospective amendment were lucidly presented. Uh, I would thank the speaker and the chairman of the session for sharing their thought experiences. Thank you, ma'am.